Hello students, my name is Sunita Sridharan. I am a lawyer and a patent agent. I am also the founder and CEO of SKS Law Associates, which is a law practice specializing in patent law and which is based in New Delhi. Today I am going to talk to you about module number 39, Patent Law Remedies. This is a slightly tricky issue when we talk about the patent law remedies. What is a remedy? Under the law, if there is a problem, then we ought to be able to remedy that problem. And how do we go about remedying that problem? And what are the problems that the patent law envisages? We shall go through them very briefly today. Now, any kind of litigation set up for purposes of finding remedies is, as you know, lies in the courts of India. The courts of India, the civil courts and the criminal courts, that is the courts which have civil jurisdiction, criminal jurisdiction or both, are very clearly defined by the way the Code of Civil Procedure and the Code of Criminal Procedure handled a particular set of subjects. The rights that accrue in cases of rights and duties and finding remedies accrue from the Constitution of India. So right at the top we have the Constitution of India, under which we have the Code of Civil Procedure and the Code of Criminal Procedure, and then we also have the various acts which decide on how or what amounts to an offence or what amounts to a civil wrong. There is also the Evidence Act, which very clearly defines what can be taken by these courts by way of evidence. And apart from the various statutory laws, we also have the common law of torts, where again we may seek remedy when a court is deemed to be sitting in equity. So very quickly, to sum up, we look at the Constitution of India, which lays down the rights and duties. It very clearly talks about the right to approach the High Court by way of a writ petition, the right to approach the Supreme Court by way of a special leave petition, the Code of Civil Procedure, which governs civil cases that may be deemed to be civil offence under the various statutes, the Code of Criminal Procedure, which governs what can and what are the procedures for criminal cases as decided wherever the offences are decided to be a criminal offence under the various statutes, and the Evidence Act, which very clearly sets out what kind of oral or documentary evidence can be adduced in court in support of whatever the contentions are of the complainant and the defendant. And above all this, there is an equitable right which can be, for which a remedy can be sought under the common law of torts. Now, coming back to what are the rights under the Patent Act, because we are looking at a particular statute, and in this particular module we will be talking about the patent law. Very quickly, to touch upon the rights of the under the statute, one of the most significant, most important right is the right of the patent owner. As you are aware from your previous modules that you have studied, Section 48 clearly enshrines what amounts to the rights of a patent owner in cases where his invention is a product and also in cases where his invention is a process. So to quickly sum up, the right under the Patent Act of a patent owner is territorial in nature. It will extend only within the jurisdiction of India. The rights are subject to the exceptions laid out in the various sections, including section 47 and 49 of the Patents Act. The patentee of a product patent has exclusive right to prevent unauthorized third parties from making, using, offering for sale, selling or importing for the purposes that particular product into India. Similarly, the rights of a patent owner for process patent is the right to exclude a third party, an unauthorized third party, from the act of using, offering for sale, selling or importing for those purposes the products obtained directly by that process into India. Also, to quickly sum up the significance of a patent, and this is very important because law is evolving. As you know, law is never stationary, it is constantly evolving. The evolution of a law is directly dependent on social evolution, technological evolution, economic evolution, and how things progress. Law has to administer to the society and the problems that arise in society, or problems that arise due to various functions of a society, such as a technological advancement, and it has to deal with that in a particular manner. So, a remedy also has to be seen from the point of view as to what really would work right for a person who is suffering under this particular law. The suffering in this case need not always be the patent owner, it can also be the infringer. And we have to understand under what circumstances, what kind of defenses help a person alleged to be an infringer, and how does a person what kind of remedies are available to a person who is suffering because somebody has infringed his right. Now, to touch upon the significance, like I was talking, the exclusivity gives the patentee the time to work his patented invention and to make money. So, the underlying need here is to commercialize, and that commercialization, when effected by third party usage, can cause great harm to the patent owner, and therefore he seeks a remedy. A patent is seen as an award to the inventor for inventing something and contributing to technological advancement of society. So, every time there is a technological advancement, there is a requirement to understand whether there is any kind of infringement, because as you are very aware, in certain areas of technology, there are platform technologies and there is patent pools which are put together which create a particular technology. This is quite opposed to a patent which is granted for a very useful molecule, a pharmaceutical molecule, and it is only that particular molecule which is the blockbuster, and for the next 20 years that is what brings in the money. Look at the technology in areas of information, communication, these areas of technology. For instance, in case of DVD, the number of patents owned by various people, various companies, amount to more than 25,000, owned by almost 150 companies, which together give a technology platform which can be then commercialized in the market. In such a situation, it becomes extremely important for a patent owner to understand at which stage his invention, his patented invention, has been infringed by another party, and what are the remedies that he can get, and would his seeking that remedy create a problem for him by which he will end up losing money in the market and reputation in the market. There are many examples in India and abroad which gives a very clear indication as to how a bona fide patent owner can suffer adversely when he takes a matter to court by way of losing money or by way of losing business or even by way of losing reputation. In some cases, when he files a suit against his opponent, which is usually his competitor, he gives so much of significance and importance and media coverage to the opponent or his competitor that the competitor actually ends up getting far more in return than a mere damages or injunction would harm him. So, there are many cases which you can look at it, and one which comes straight to mind is that of Apple versus Samsung. Samsung suddenly became very important player in the mobile phone market thanks to this particular litigation which ranged across multiple countries on many jurisdictions across the world. So, it is a matter of a business decision for a patent owner as to whether he wants to seek remedy by way of approaching courts or seek a remedy by way of negotiating a deal and settling the matter between the infringer with the infringer. To just capture another point before we go on to the remedies that are available, the patent applicant or the owner is usually the inventor. Under the Indian law, it can also be the assignee of the inventor. So, if the inventor has assigned his rights to a company, the company is the patent owner. The rights can also devolve, the patent rights can also devolve to the legal heir of the patent owner. So, if there was a person who had a patent right and he was a patent holder, on his demise, the rights by operation of law can devolve to his legal heir and he becomes the patent owner. There is another angle to this, and that comes through voluntary license. The reason I say voluntary license and the reason why I bring it into this patent law remedies is because the patent law very clearly gives rights to the exclusive licensee to sue, just like he is the patent owner. This is very interesting. So, we are talking about an exclusive license holder, and as you understand, an exclusive licensee and a non-exclusive licensee. The difference between the two is, in case of an exclusive license, the exclusive licensee excludes even the patent owner from having rights to exercise his rights. When the patent license, the exclusive license comes to an end, the right goes back to the patent owner. But during the term or the existence of the exclusive patent license, the exclusive licensee has a right to exercise all the patent rights enshrined in section 48 and can exclude even the patent owner. And the Patent Act of 1970 very clearly gives rights to the exclusive licensee to also seek remedy wherever there is a problem. And therefore, it is very important to understand that a patent owner can also be, for purposes of seeking remedy, the exclusive licensee. And it's very interesting, when an exclusive licensee sues and he finds that the patent owner is not interested in pursuing the matter, then the exclusive licensee can name the patent owner as the defendant also. That means, in the memo of parties which he files in the court, you will have the main defendant, the defendant number 1, the one who is infringing, and the last defendant would be the patent owner, and this is just for purposes of executing or for the purposes of seeking a remedy. Now, what are the actionable problems under the patent law? Infringement of patent rights of a patentee is enshrined in Section 104 of the Patents Act. It very clearly states that it is a civil action, it's a civil offence, and therefore you would approach for remedy to a civil court. The Section 104 very clearly states that the court of least jurisdiction in such a matter is the district court. So, one assumes that if the pecuniary jurisdiction for a given state in which the jurisdiction lies, the territorial jurisdiction lies, is below the mandated amount as per the state rules, then it will lie in the district court. The proviso to Section 104 is very interesting. It says that if the defendant files a counterclaim for revocation, then in that case, if the matter is in district court, the entire suit for infringement along with the counterclaim for revocation shall be shifted to the High Court. That means that it is the High Court which has the jurisdiction in this case. We have had an instance where the matter was listed before the district court. This is in District Court Almora, and a counterclaim for revocation was filed by the defendant. The district court judge refused to transfer this case to the High Court as it is required under the Section 104 of the Patents Act. The defendant in this case filed a writ petition in the High Court at Nainital for direction to the district court judge to transfer the entire case, the suit for infringement, along with the counterclaim for revocation to the High Court. The High Court at Nainital gave an order to passed an order to the district court judge, district court, for the transfer of files, the entire set of files, to the High Court, since the jurisdiction now lies in the High Court. So, there was a very interesting use of both the civil courts as well as a writ petition in this particular case. In cases, there are also other cases, and we shall go into the remedies in a little while. There are also other instances under the Patent Act where an action is an offence or an action is a civil wrong. One very important action which amounts to a criminal offence, and there are a few which are there very clearly mentioned in Section 118, that is Section 118 of the Patents Act, which very clearly lists out what are the offences and what are the penalties. And one very important one that we all must remember is the one where the requirements under Section 39 of the Patents Act have not been complied with. What does Section 39 of the Patents Act say? It says that any person who is a resident of India is desirous of filing a patent application abroad. He must first file it in India, or if he does not file it in India, he must obtain a foreign filing license from the patent office before filing his application in a country of his choice, in any other country. So, under Section 39, either you file a patent application in India, wait for 6 weeks and then file it in any country of your choice, or if you do not want to file that patent application in India, Then you obtain a foreign filing license from the patent office, and then you file your application in countries of your choice. Failure to do so under section 118 attracts criminal action. It is imprisonment and or fine. So this is one of the instances where there is no recourse to correct a wrong. If you have committed the wrong, then there is a penalty. It's a different story that as of now, the patent office has not taken any action in any instances that have come up before it. I think in most of the times people have done the right thing of getting a foreign filing license. But slowly, because of a global platform, because of a number of collaborations between Indian and foreign companies, or Indian universities and foreign universities, or the public-private partnerships that are going on, it is likely that this problem can occur in future. And the only remedy here is, in fact, there is no remedy because it's straightforward a criminal offense. Another very significant one which is available is a declaration of non-infringement under section 105 of the Patents Act, and groundless threats of infringement proceedings under section 106. You may well ask what these mean, and I know that we have tried to use these provisions before the court of law. In the first case, that is under section 105, you approach the court for a declaration of non-infringement. But the problem here is there is no cause of action. It has not happened. The action has not happened. You are anticipating that there is an action that could happen, and you have approached the court for a declaration, a declaratory protection. And this can get extremely tricky. If you approach the court after you have been sued for infringement, the defendant is told by the court that there is no remedy here because he's already been sued for infringement. If the person approaches the court as a petitioner and seeks for a declaration of a non-infringement, then the court says that there is no cause of action yet, and therefore the matter is dismissed. Now, how do we really understand how important this is? This is extremely important, and that becomes very, very important where we are looking at technology benchmarks, technology standards, standardized technologies, standard patents. It becomes extremely important in such cases to have a declaration of non-infringement. The second one is again a very important one, that is the section 106. It talks about groundless threats of infringement proceedings. Now, when it's a normal action by any law firm or by any person who is aggrieved when he feels that somebody is infringing his patent rights, to send what is known as a cease and desist letter. A cease and desist letter is a way of telling the other person, that is the infringer or the alleged infringer, that look, I have a right in this particular invention. I have been granted a patent, and what you are doing amounts to an infringement. So kindly cease and desist from infringements. In almost 90% of the cases, a cease and desist letter is extremely useful, and it immediately stops infringement actions. Most lawyers would ideally ought to use this, and most of the people, aggrieved patent owners, use this. This also gives a leverage to negotiate and to settle the matter, to mediate, to appoint an arbitrator. and come to an agreement. In one of the instances where I cannot divulge the name, where a cease and desist letter was issued and served on the other party, the alleged infringer, approached the patent owner and sought for a license and ended up having a very lucrative license arrangement with the previous, as you would call him, the alleged infringer. And that was a very, very useful one, but unfortunately, since it is a trade secret, there is no way I can discuss this and explain that to you as to who the parties involved were. But if under the Patent Act, if there is a case of groundless threats of infringement, then you can approach the court for some kind of a relief so that the court would stay the other party or injunct the other party from issuing such threats. Whether a cease and desist letter amounts to such a threat? No. In my opinion, it does not amount to such a threat where there are bona fide reasons, there is a bona fide cause, there is a bona fide documents which are available, which are appended to this and served along with the cease and desist letter to the alleged infringer. However, if there are letters coming to the alleged infringer on a regular basis by a third party, it could also be seen as a kind of an anti-competitive practice done by a competitor to undermine the so-called alleged infringer and spoil his business. Because after all, at the end of the day, the entire patent law is on the basis of the fact that every patent which is granted by the Government of India shall be worked as a for commercial purposes. Now, where do you approach, or who do you go to? Which are the courts that you approach for purposes of remedy? Like I said earlier, if you are aggrieved with regard to an infringement or any of these matters, the lowest court is a district court. If you are aggrieved because your patent has been revoked, or there is a revocation proceeding, or the patent is being granted to someone in which the patent is not there, or it is not a patentable subject matter, or it does not fulfill the requirement of patentability, you would approach the Intellectual Property Appellate Board, IPAB, which is based in Chennai. If there is, as in case of the previous one which I mentioned, I did not give you the cause title, that is Acme versus Interlux, the matter which was heard in Almora, District Court Almora, and then transferred to High Court. You can also approach the High Court or the Supreme Court by way of a writ petition or a special leave petition under the Constitution of India and exercise your rights there. And where, based on your pecuniary jurisdiction, you can easily go to the High Court of that particular place where there is a territorial jurisdiction. Like I mentioned before, the territorial jurisdiction in case of an infringement of patents is a civil court, and it would lie in the least is the district court, and then accordingly in the High Court based on the pecuniary jurisdiction. Post 2005 patent amendments, there have been a large number of patent litigation. Almost 75% of the patent litigation is in the pharma sector. The decisions that we have had from the court have been on as wide area as patent linkage with the drug regulatory system, the right of the pre-grant opponent to be heard in an appeal, and this was in the first business method case which was heard in the IPAB. The Section 8 compliance, where it said very clearly that because you have not complied with Section 8, which requires you to file the details of foreign applications and the corresponding foreign applications at the Indian Patent Office, and the patent was revoked, and the various injunctions. So, the remedies that are available under Section 108 of the Patents Act are injunction. So, you would have a temporary injunction and you can file for a temporary injunction, but you aim for a permanent injunction, which means that when you file a suit for infringement, you will also file an application for a temporary injunction. An injunction, as you know, is not a statutory right, it's an equitable remedy, it's a right in equity, and based on the various the requirements that the court may look at, for instance, balance of rights, the prima facie case, the balance of convenience, irreparable injury that the plaintiff faces, the court may grant him a temporary injunction. A permanent injunction is what every plaintiff would aim for at the end of the trial. The court may also grant damages or accounts of profits. This is at the option of the plaintiff as a remedy. Another remedy that the court may order is a seizure and destruction of infringing goods. Another remedy that the court may look at, and it is very difficult in patent law because we are talking about patent infringement, and we are talking, as I said earlier, almost 75% of the cases are dealing with pharma cases. It is very difficult for the court to really come to a decision at a very early stage to decide whether there is actually an infringement or not. So, to sum up, the courts under Section 108 of the Patents Act order injunction in case of, I am talking in case of infringement, any suit for infringement may order injunction, and a temporary injunction is something which any plaintiff would seek at the first instance. A permanent injunction is something that he would look forward to at the end of the trial. Damages or accounts of profits at the option of the plaintiff. So, the court may well order the defendant to keep the books of accounts so that the accounts for profits can be calculated, computed, and the same can be paid to the plaintiff if the plaintiff wins the case at the end of the entire trial. The court may also order seizure and destruction of infringing goods. Now, as I mentioned earlier, almost 75% of the cases of infringement deal with pharma matters. Almost all pharma matters are highly complicated in nature when it comes to understanding the technology therein. It is far more complicated than, for instance, patented technology relating to a mechanical instrument or electrical device or an electromechanical device. The chemistry involved in pharmaceuticals also requires a lot of data and evidence and tests to be conducted and submitted to the court. It is not easy to really have an early decision or an early remedy in such cases, and it may well be that the remedy that is received may not really justify the situation. In such a situation, many countries, I do not know of any instance where India has adopted this or Indian courts have adopted this, but many countries use one of the mechanisms available under arbitration, where by way of an appointment of a court commissioner who has an amicus curiae, who is well versed in the chemistry of the subject, arrives at an understanding of the subject matter understands whether there is an actual infringement of the claims which have been granted patent, and submits this report to the court so that the court can then adjudicate on this based on the findings of the court commissioner, who has been assisted by the amicus curiae. To conclude this particular module 39 and to summarize it, we often think of remedies under the patent law only insofar as patent infringement is concerned. We must remember that there are other remedies also for other problems that can be availed under the Patent Act. There has to be a deeper understanding of the issues, a deeper understanding of the solutions that can be availed under the Patent Act and also through negotiations and arbitration. Thank you.